Merci, Monsieur le Président, et merci à mes collègues ici. Ce projet de loi C-51, ce n'est pas seulement affreux, c'est un projet de loi dangereux. And I want to pause for a moment, Mr. Speaker, because this is not an ordinary debate and this is not an ordinary bill. And this is not about politics anymore. This is about the soul of the country and a question of whether we understand what Canada stands for ourselves and what we represent around the world. Now, we just bowed our heads in prayer. The Supreme Court has taken a look at bowing our heads in prayer, and we may be visiting that someday, but we just, through the words of the Speaker, asked us to pray that we make good laws and wise decisions. If we meant that prayer and then we pass C-51, our words are blasphemy, because this is neither a good law nor is it wise. The story that the Prime Minister would like to have Canadians believe about this law is that in this place, some members of Parliament belonging to the Conservative Party want to protect Canadians from terrorism, and other members of Parliament, namely Greens, the New Democrats, Bloc, some independents, and I certainly hope in future the Liberal Party will come to its senses and join us, that those of us who will vote against C-51 don't care about security. And certainly, in the course of clause by clause, various Conservative members of that committee actually said, what a shame the Green Party is willing to, I think the words used were, privilege the rights of terrorists above those of Canadians. Now, that's the story that Conservatives want Canadians to hear, to think that we are so concerned with rights and freedoms and the Charter of Rights and Freedoms and civil liberty that we would turn a blind eye to the threat of terrorism. When this law was first tabled, and of course it was initially launched at a campaign-style rally in Richmond Hill, Ontario, and not in this place, something I guess we're becoming all too familiar with is sort of a routine contempt of Parliament by launching big initiatives and laws outside of Parliament with cheering crowds and campaign banners. But when this was first launched, the Prime Minister said, quote, "Violent jihadism is not a human right. It is an act of war," unquote. It was an extraordinary thing to say, as if anyone had ever suggested that violent jihadism was a human right. It set up a frame in which those of us who oppose Bill C-51 are somehow associating ourselves with violent jihadism. Now, in response to that torqued campaign rhetoric, we have the words and the advice of some of the country's leading constitutional and security, legal and operational security experts. In relation to this notion of an act of war, the words from Professor Craig Forsyth from University of Ottawa and Kent Roach from University of Toronto, who said, quote, "False analogies between crime and war can contort law." We need to look at this bill, which is an omnibus bill of 5 different sections, 5 different laws thrown together and rushed through Parliament, and rushed through committee, and ask the question, does this make us safer? Don't fall into the trap, and I ask my colleagues, don't fall into the trap of saying it's civil liberties versus protecting us from terrorism. Does this bill make us safer? Does it actually confront terrorism in a fashion that makes Canadians safer? Then we can have the discussion of whether we're willing to make compromises about civil liberties because the bill will make us safer. You see how cleverly the Conservative spin puts us wrong-footed before we even begin. The assumption is the bill makes us safer. And I want to spend most of my time this morning at report stage to persuade as many colleagues as I can that this bill is dangerous because it makes us less safe, while pretending that all of the losses of civil liberties that this bill represents, the violations of privacy, and indeed the most unprecedented anti-constitutional, anti-democratic provision in any law that's ever come before this place, a law to allow a CSIS agent in a secret trial before a judge where the only evidence presented is from the government and the existence of the hearing will never be known to the public, to provide a CSIS agent with a warrant to violate our Constitution. It's astonishing, a constitutional breach warrant. But let's look at this question. Does the bill make us safer? after the rush of witnesses through the House, they already began the hearings in the Senate. So before we've completed our review of the bill in this place, here we are at report stage, the other place has already begun its review. And I think some of the most powerful testimony yet on C-51 came up in the Senate from a British security expert who has worked as a liaison officer within the Canadian security establishment. In other words, he's an operational spy. He has worked for MI5, he's worked as a security aide, and he's worked in Canada as a liaison officer with Canadian security. He's an expert. He's an expert in what we need to do to make us safer, to find and stop terrorist plots. His name is Joe Fogarty. He introduced himself to the Senate. I have his testimony before me that he was asked repeatedly, and here I'll quote from him. The question I was asked to address was why it appeared to be the case that the relationship between the police service and MI5 in the United Kingdom was so close, with such easy sharing of information, and with a consistently strong outcome in terms of arrests, prosecutions, and convictions in national security cases. Close quote. He contrasts that since 2001 in Canada, there have been 30 terrorism-related arrests, whereas in the UK, there have been some 2,000. Now, and those figures, by the way, did not include Northern Ireland. Well, it could just be that we don't have very much terrorism activity here, but it also could be that we've set up through silos security services and police operations that don't work with each other and actually can trip each other up. In that connection, he gave further testimony, which I found quite shocking, and he said this is all on the public record, but it's not that easy to find. These examples, for instance, were put forward. These are recent. CSIS discovered the location of a suspected terrorist training camp inside Canada, but it decided not to tell the RCMP about it. Another example. CSIS realized that the RCMP was following the wrong targets. And here I quote Mr. Fogarty. So having identified certain people who were believed at that stage to be threats to public safety, and realizing the RCMP was following the wrong people, CSIS decided not to say anything. Now, this evidence from Mr. Fogarty, and I'll come back to it, is directly relevant to testimony that the House of Commons Committee did hear, because John Major, former Supreme Court Justice, who chaired the Air India inquiry, pleaded with the committee not to pass the bill in its current form, not to pass it without oversight. What we've done in this bill, in Part 4, is to create in CSIS new powers of disruption and to give them access, as I mentioned earlier, to be able to get a warrant from a judge, to break domestic law, and to violate the Charter of Rights and Freedoms. But CSIS agents are nowhere in Bill C-51 required to share information with the RCMP. Now, you'll hear from conservatives, oh, don't worry, because Part 1 of the bill is all about information sharing. Yes, the words information sharing are used, but they're not about sharing information between CSIS, Canadian Border Security Services, CSEC, and the RCMP. Those are the 4 different agencies that are collecting information and have a role in disrupting terrorist plots. There's no oversight. There's no pinnacle command. There's nobody watching what each entity is doing, and there's no requirement to share information. On the contrary, we've set up a system where there are disincentives to sharing information. Now, Mr. Fogarty testified very clearly that in the UK, due to a law that they passed back in 1996, they created a situation where under this legislation, all national security material is afforded third-party status in criminal proceedings as a matter of statute. With that assurance, you then get in the case of the UK, your police working with MI5. In Canada, we don't do that. So what Mr. Fogarty actually found about this legislation and our current system, and of course, our current system lacks any oversight. Can't say that clearly enough. We have a review committee in CERC, but that's not oversight. So here we have a situation where a security expert came before Parliament to the Senate committee and said, quote, at this minute, quote, with the greatest respect, if you continue with the situation in which your security intelligence agency is reluctant, for very good reasons, to share with your law enforcement team, this is the equivalent of sitting on top of a tragedy waiting to happen. I was asked this question a number of years ago, continuing with Mr. Fogarty's testimony to the Senate, and I was asked to have a look at which bits of the Canadian operational relationship I would incorporate into the UK, because as liaison officers, we are very acquisitive and looking for best practices all over the world. With the greatest of respect, I wouldn't incorporate a single aspect of it at the minute because it's dangerous, close quote. So here we are being told by the Conservatives and the Prime Minister that we must accept a bill that tramples on the Constitution, tramples on our rights and freedoms, violates our privacy rights, because it will make us safer. And here's the big lie. It will not make us safer. It is dangerous. It will make us less safe. It will create circumstances in which CSIS and the RCMP operate in silos. That led to the Air India disaster. I plead with my colleagues, reject this bad law.
Questions and comments. The honourable member for West Vancouver, Sunshine Coast, Sea to Sky Country.
Well, Mr. Speaker, I was pleased to hear my friend and colleague from Sandwich Gulf Islands refer to my former political science prof and others. But aside from that, I have to take umbrage with much of what she said. The bill is designed to bring our government up to the level of other Western democracies. It's modest in the changes it would make, given the threats that we as Canadians confront. And I would ask two questions. First, Mr. Speaker, I would ask, does my friend have to be confronted personally by a knife-wielding terrorist for her to understand that the threat really is out there and that Canadians need to face it? And secondly, why would she oppose a bill which seeks to bring judicial overview of the kinds of measures that we're looking at, as opposed to the executive approval that is used in other Western democracies, much less cumbersome and unwieldy than judicial oversight?
Member for Saanich Gulf Islands.
Well, my friend from West Vancouver, Sunshine Coast, Sea to Sky Country misunderstands if he thinks my speech said I did not take terrorism seriously. I take it seriously. The Conservatives don't, because they've put forward a bill that will create a situation in which we are less safe. And as to the specific circumstances of the words judicial oversight, I would tell Mr. Speaker, let's be clear, this bill does not contain a single element of judicial oversight. It does allow a CSIS agent to go to a judge and obtain a warrant, but does that judge have the overview and the oversight to continue to monitor the way that warrant is used? And no other modern democracy, none, anywhere, would allow a judge in a secret hearing to give a warrant to violate the Constitution. It is unheard of in the democratic world. It's unheard of, period, and this Parliament should not stand for it.
Questions and comments. The honourable member for Beauport-Limoilou.
Oui. Merci, Monsieur le Président. Merci à la députée de Saanich Gulf Island pour son discours. Elle a soulevé justement des objections très, très sérieuses par rapport aux périls liés au projet de loi C-51. Il faut dire que dans le cadre d'une étude sur le financement du terrorisme au sein du Comité des finances, je me suis retrouvé à parler en marge des travaux du comité avec le commissaire à la protection des renseignements personnels, M. Daniel Terrien. Et M. Terrien me confirmait une impression que j'avais, c'est-à-dire que, pour prendre l'exemple d'une agence de l'Agence de revenus du Canada qui est touchée parmi les agences et ministères du gouvernement fédéral là, par le projet de loi, l'agence pouvait se retrouver à communiquer très librement, potentiellement, des informations de dossiers fiscaux de particuliers. Alors, M. Terrien me le confirmait. Je voudrais que la députée puisse probablement élaborer sur d'autres exemples de transfert d'informations trop larges, potentiellement abusifs, dont que le projet de loi pourrait permettre.
Honourable member for Saanich Gulf Islands.
Merci à mon collègue. Moi-même aussi, j'étais choquée de constater que le commissaire à la protection de la vie privée du Canada n'a même pas été invité à témoigner devant le comité. Et je comprends bien parce que j'étais là quand les députés MPD ont fait l'effort d'inviter ce commissionnaire. Alors, qu'est-ce qu'on peut penser des intentions d'un gouvernement qui arrêtait le commissaire de privé du Canada de faire le témoignage? Alors, c'est clair que ce projet de loi est dangereux et va violer les droits des Canadiens.
We had time for one more short question and response. The honourable member for Winnipeg North.
Mr. Speaker, very quickly, Liberal parties indicated one of the biggest missings of this legislation is the parliamentary oversight, something in which we believe is absolutely critical. But we recognize that there is some value to the legislation. Even the New Democrats have indicated that if they were elected in government in fall, that they would not repeal the Act. The question that I have for the member is, does she see any value whatsoever to the legislation? Is there any valuable aspect of the legislation that she thinks would be of benefit to Canadians?
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable friend for Winnipeg North. There's virtually nothing. I would say the one thing in here that would be of value would be the ability to stop someone from boarding a plane. On the no-fly list right now, it's restricted to people who pose a danger to the flight, as opposed to someone seeking to leave Canada to join foreign fighters. Other than that, this entire bill, in other words, this bill is so bad that neither opposition party in this House, should they ever form government, should imagine that it can be fixed with amendments. If the horror of this passes this place, which I still hope will not happen, I still think if the Liberals were to change and vote with the rest of the opposition parties, that there are enough Conservatives of conscience that this would not pass. But if it does pass after the next election, it must be repealed, and then the small change to the no-fly list can be made. Thank you.